Great. Okay, today we have with us Adam Ainslie, who is a partner at Collins Collins, where he litigates cases throughout California. He often represents lawyers in legal malpractice claims, particularly in the area of trust and estates. And then we have our own Amanda Moghaddam, who most of you really probably already know. She's our immediate past president of the SFVBA. She's a claims attorney with Lawyers Mutual, and she's so much a valued speaker for us, especially in the area of legal ethics. So, welcome
Okay.
you both, and we're excited to get started. Thank you.
Well, thanks, Linda. And thanks everybody for joining us today. So, our presentation is going to be When Good Plans Go Bad, Ethics and Risk Management in Trust and Estate Practice. I am going to try to monitor the chat. So, if there's a question that's on topic, hopefully I will see it as Adam and I are going back and forth. It's our sincere hope that this will be conversational between the two of us as opposed to a lecture. So if you have a question, pop it in the chat, and then we will stay on a little bit extra at the very end to answer any questions if you want to verbalize them then. Okay. All right. Let's hope that all my tech works. Okay. So just a brief overview of where we're going today. We're going to talk about conflicts of interest, especially when you're managing multi-party representation and dealing with also fun family dynamics. We're going to talk about capacity challenges, how to determine competency, how to farm that out, and undue influence so that you know what the red flags are. Most of you probably do, but it's always good to touch on this again. And then risk management techniques. So that's sort of the signpost of where we're headed. All right, so we're going to start today with Rule 1.7. It's your primary conflict of interest rule that comes up very frequently. Says that where there is a significant risk that the lawyer's representation will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by the lawyer's own interest, the representation has to be documented. You have to get informed written consent to that representation and get a conflict waiver. So we're going to talk about Rule 1.7 first, and how in estate planning, it's often not at the outset, but as family dynamics evolve during representation, that these conflict of interests start to pop up. It's usually not at the beginning. Everybody's getting
I
along
don't
well when they come to the
understand.
attorney's office. Just a reminder, if you're on there, if you can mute yourself, I'm hearing some background noise. I think there's a couple people not on mute. So if you could do that, that would greatly help my undiagnosed ADHD. Thank you. Okay. So, we're going to talk about how when everybody comes into your office, they're all hunky dory. Mom loves all the kids, kids love mom back. But those things tend to change over time. So, we're going to talk about those conflict waivers, when to update them, and when to withdraw. Um, One of my key takeaways today is that I hope when you get a written conflict waiver, you will remember that specificity is key. What I want to see in those conflict waivers so that you don't end up on Adam's desk, right? Adam is a defense lawyer who gets appointed by companies such as mine to defend lawyers when things have already gone wrong. Hopefully, you won't end up on Adam's desk because you have a very specific conflict waiver. We're going to talk about what specificity means. So I'm done signposting for the whole thing. We're gonna jump into it. So our first real substantive topic is multi-party representation, and specifically what happens when you take on joint representations of a spouse in an estate plan. I'm not going to just read to you guys, so we're going to kind of talk about some of these stories and what comes up. The primary example I see all the time is husband and wife come in, they ask for an estate plan. After the estate plan's prepared, they're getting a divorce, so they're now directly adverse to one another. from an estate plan that the lawyer drafted, and that can create a big problem. Adam, any case stories you want to tell us with that
Yeah.
specific fact pattern? Because I feel like it comes up a good bit.
Yes, I currently have one right now where that is an issue. Fortunately, there the lawyer who did the estate plan did made the right decision and said, "I'm not going to represent either of you. You need to go and get your own individual counsel," which is always the best. But just to even take a step back a little bit, uh, you know, yes, we're talking about trust and estates here, but in my practice at my firm, we basically have a policy of anytime we are representing more than one person, we're having a conflict waiver. It is just a good practice to have, even if these are two people that will almost never have a conflict with each other. It is, you never know what's going to happen down the line. And you'll be kicking yourself later when you didn't have that waiver.
Yep.
So it's something we strongly recommend just at the outset. It should be almost as standardized as a practice as having a retainer agreement signed. I mean,
I agree. My
it
first boss taught me that. He said, you got two clients, you better have a conflict waiver in that file if I go pick it up.
yeah, absolutely. And so that's going to be the first thing. But in rarely, I mean, we're almost never dealing with actual conflicts at the outset. It's always, I mean, if you're taking something on, there's an actual conflict at the outset. We should talk because that's a
You
much
should
bigger issue.
you should
Uh,
probably be declining the representation if there's an actual conflict at the outset. Yeah.
exactly. It's always there's a potential or what you've kind of described as the hidden potential ones. And the hidden potential ones are the ones that are, as the defense lawyer, the scariest, because those are the ones that you didn't plan for and account for and end up hurting us if there is a malpractice case. And a conflict waiver, the lack of a conflict waiver itself is not a basis for malpractice liability. Um, I think an important topic here is that talking about the rules of professional conduct. Rules of professional conduct do not automatically mean a breach of duty of care and negligence. In fact, there's case law that says you don't get to use the rules of professional conduct to establish negligence. That actually goes to a breach of fiduciary duty.
Mhm.
But I think 9 out of 10 lawsuits that I see will have multiple causes of action. You'll have negligence, legal malpractice, or professional liability. You'll have breach of fiduciary duty. You'll have breach of contract for your signed retainer agreement. And there can be other theories as well. So adhering to the rule and also adhering to the rules is important because you don't want to also be tendering over to someone like Amanda saying, "Hey, the state bar is investigating me for
Right.
XYZ."
Right.
So it's not just getting sued is the issue. It's we do have a regulatory board that will investigate. We all
Mhm.
know that there's been a uptick in enforcement over the last couple of years. I've certainly seen more uh, in my practice. So it just making this a standard practice is I think really the easiest thing. It should be an attachment to your retainer agreement, and even if it's not joint representation, it's a single client, and you can just say, "Oh, ignore that" and cross it out. But there's no risk of having it.
Well, and talking about, potential conflicts, right? Or I'm sorry, potential consequences. So Adam mentioned, when it comes to the rules of professional conduct, that may not necessarily give rise to a legal malpractice suit. But what can happen is if you earn a legal fee in a situation where you didn't get a conflict waiver, your fee is on the line. So if you're not motivated by, worrying about the state bar coming after you and you're not motivated by lack of legal malpractice, be motivated by money because your fee could be on the line if you engage in conflicted representation. You could be ordered to disgorge your legal fees that were earned as a result of the conflict. So that's another consequence I'd add there. That's another reason to really care and make sure you're complying with the conflict of interest waiver rules. So a couple of things that I just wanted to mention from the rules because the language in the rule itself can sometimes be confusing. I want to talk about this language. First, what does direct adversity mean? Direct adversity would be the situation where the husband and wife come back to modify an estate plan and they're now in a divorce. I would say that those are two directly adverse clients. And what Adam just said is exactly right. Luckily, the attorney he's defending in that situation said, no, go get your own lawyer. That's absolutely what you need to do under that circumstance. You can't pick a side and help. And even if they think that they can be neutral, it's really better for everybody to have their own set of eyes on that amended estate plan.
And let me add this as well, because you mentioned divorce. Uh, I've actually seen in my practice more often is it's not actually a divorce, but it's just usually with elderly clients that know end is coming near and they're trying to take a care of affairs. And husband and wife have multiple children. They have differing views as to how the children are going to be benefited. Sometimes it usually starts out as an equal, when they created this, and then years have gone by, things have happened with children, and now one child may not be as favorited, or one is more favorited, and they want to not devise things equally. And sometimes, this isn't a perfect example. I had a case where mom and dad went to revise their estate plan, or husband and wife, and wife wanted to leave more or everything to the eldest son for cultural reasons. That's just in their culture. The eldest son gets everything. That's just how it works. Dad didn't agree with that and wanted to give to daughters. Um,
Whoa,
and
that's quite a big conflict right there.
and that right there was, can't help you. You need to go and get your own. Um, it still came to us because there was alleged malpractice in how dad/husband went about revoking that family trust, because those are issues that we see. Bloodbath of litigation ensued, obviously, after dad died, because dad wanted everything to go to daughters and mom wanted everything to go to sons. And so that's where we see the conflict of interest. Had that lawyer done the revision, they would have had to choose between who you're going to follow. You're going to follow. It's not even possible. You following the dad and giving everything to daughters, or are you following mom and giving it to the son? It's, the two things can't be true there. The lawyer has to pick one or the other, which is obviously a huge no-no when
Right.
it comes to the rules of professional responsibility.
Yeah. And even if you don't look at the actual rules themselves in that situation, this is what I call sort of that gut check, right? Where my duty of loyalty to one client is impossible to carry out because of my duty of loyalty to the other client. And when that happens, that's a circumstance where you can't go forward with the representation. If there's active litigation, you've got to withdraw or you need to terminate the representation, right? So that's a really helpful example. Um, let's see, what else did I want to mention before we move on to the next slide? Material limitation. It means not just that there's a minor conflict, right? Material is more like the circumstances of what Adam and I are talking about. So it's not the fact that maybe they got in a little spat in your office, right? And they seem to be kind of angry at each other over getting cut off in traffic. That's not what we're talking about. A material limitation means just that. It means material, right? It has to be kind of a bigger deal. Um, let's see, what did I want to say? Oh, about material limitations. It's particularly relevant in a spousal estate plan where individual financial goals or familial relationships, like what Adam was just saying, could materially limit the attorney's ability to represent both spouses faithfully. So there are some times at the outset of the representation where someone brought perhaps stepchildren to the marriage, right? Different family dynamics that might affect the estate plan can create a conflict. Let's see. And then in order for it to be permissible, if you have a conflict, you have to get a waiver. In order to say, okay, I'm going to move forward with a waiver, you have to look at three things. Number one, do you believe you can provide competent and diligent representation to each affected client? Usually the answer is yes, but if there's some reason that that's not true, you need to reflect on that. Representation can't be prohibited by law. That doesn't really come up in a lot of these contexts. And each client has to give informed written consent to the representation. If your conflict waiver isn't signed, it didn't happen. Okay. If it's not in writing, it didn't happen. If it's just mentioned in a, billing entry, okay, I'm glad you had the conversation, but you're making Adam's life a lot harder. Okay. If the conflict waiver needs to be in writing, signed by both clients, and it needs to be specific. They need to understand what the conflicts are in the situation that Adam just described. The conflicts are that you both want different estate plans, right? Specifically, one wants one thing to go to one kid, one wants the other. It has to all be laid out. And if they can't give informed consent to that, right? They can't consent to it, then they need their own lawyers. So,
And even the other thing is too is going back to those 3 points. Even if you can, it doesn't mean you should,
correct.
because you can get, yes, they might sign the waiver, but it goes back to that first point of, can you competently represent them? You still have to be able to effectuate what they're requesting. So you can't get them to agree to waive a conflict, but then not be able to complete the representation and the job that you've been hired to do. And that's still going to be a problem. That is a conflict that I would call unwaivable, because you inherent, and to the extent you do, you end up walking into a malpractice trap, because you will fall below the standard of care and you're getting sued solely because you tried to do a representation that you shouldn't have. Your best situation in that is to or take on one if you have the waiver, and it's okay to take on one and it wouldn't be a problem with someone else representing. You start getting into some privilege issues there, but usually your best course of action is just to say pass to the whole thing and wait for the next one to come in.
Yeah, I 100% agree. And it's a nice segue into our next point, which is if there's an actual conflict at the outset, Adam and I already said this, it's probable that representation is not appropriate, right? It's probable that you need to decline that case. It's only when there's potential conflicts that you can continue with the joint representation and get the waiver. And to Adam's point, I've seen these cases where the clients both signed off on the waiver, but the legal malpractice plaintiff lawyer comes in and they say, no dice, because it was an unwaivable conflict of interest, right? Perhaps you had two people that essentially were setting it up for them to be on both sides of the V. That might be an unwaivable conflict of interest. So if it's at the outset, you got to decline if there's any kind of actual conflict. Let's see. We already talked about what informed written consent means. Need a thorough explanation of the implications, the risks, and the potential adverse consequences of joint representation. Anytime you have two clients and you're getting a conflict waiver, you need to make it crystal clear that there is no confidentiality as among them. I see lawyers miss this all the time in their conflict waivers. And inevitably, when the joint clients end up fighting one another, they point to the lawyer who goes, wait, you can't tell me something that I can't tell Joe Schmo, your joint client, right? Because all of that information is shareable to everyone who's part of that attorney-client relationship in that joint client context. So you need to make sure your waiver says there's no privilege among you. If any of you tell me anything, I've got to tell it to the other party. You can't tell me something and tell me I can't tell it to the other. Okay. It doesn't work that way.
That's a giant red flag for me. If a client is saying, I got to tell you something, you can't tell it to the others, that should be shooting up that antenna that, hey, there's possible conflicts here, and maybe I don't want to be involved in this, because 100%. That right there is, there's no secrets amongst all the people in the representation. It's a joint representation. Everything is shareable between them. And if someone's saying it's not, that means that they have some potential conflict with the other side.
Exactly. Even if you don't know what it is yet, right? Maybe you haven't discovered what the potential conflict is, but the very fact they're saying don't share this is a huge red flag. I agree. Probably time to withdraw once someone starts saying things like that. Let's see. We talked about no sh that any everything gets shared among joint clients. And then if during the course of the representation an actual conflict arises between the spouses and it can't be resolved, or if the attorney can no longer provide competent and diligent representation, maybe you can't be loyal to both at the same time. If that duty of loyalty is getting implicated, then it's time to withdraw from representing both. When you withdraw from representing both, remember you can never pick and choose. You can't keep one. You've got to drop both clients.
And I want to add one point there is a request to everyone here. Please just put it in writing.
Yeah.
I know you had the meeting in person, and that is great. And you may even have a billing entry that reflects it, but I'm begging you, please just put it in writing. The amount of cases that I have dealt with where it is basically, well, it wasn't in writing, it didn't exist. Even if that letter is a CYA for yourself as a lawyer, put it in writing. There's a reason we call it a CYA letter to begin with, because it will come back and haunt you in the malpractice case. Simple letter, just like when you decline representation and you send out the letter advising that you're not taking it on. It's the same thing as to why you're saying, hey, I can no longer represent you. There's a conflict here, or there's a potential conflict here, and I don't feel comfortable taking this on. I advise you to get independent counsel. If there's anything impending, if you're doing any litigation, obviously we need to keep people advised of important things like statute of limitation deadlines and things like that. If you're a pure transactional lawyer and you're just drafting estate plans, there still might be urgency involved depending on, the unique facts of each case and circumstances there. But put that in a letter, put it in an email, save it to your file somewhere so you keep it in safeguarded places, because that is what will save you when the lawsuit comes.
Yeah, 100% agree. And again, if it's not in writing, it didn't happen. Most of our cases that we see come across our desk are not necessarily because the attorney mishandled, right? Like we will frequently have an attorney who says, I talked to them about it. I spent hours on the phone. I know I documented it. I can't find it. Or I didn't think I had to get it down into writing because we talked about it so extensively. Those are the cases where Adam can't get you out on summary judgment. We're going to either have to try the case or we're probably going to have to settle it because it's a he said, she said, right? So you will make your defense lawyer's job much easier and you will save yourself some liability, right? You will immediately take down the value of any potential claim against you if it's documented in writing.
I have a great war story here. I tried a malpractice case last March. Clients paid out of pocket for it because there was no insurance money left because burning policy, and it went through the limits because of years of litigation. The plaintiffs didn't want to take the money, and so we had to litigate it. It was an underlying case was personal injury, toxic tort, so not estate planning. But the issue is that one of the two plaintiffs in the case, but really both of them, they started losing their competency during the case, largely due to the medication that they were being prescribed by their doctors.
Wow.
Both plaintiffs went crazy, for lack of a better term. And my clients, in thinking that this was the best thing to do because communicating was becoming more difficult, instead of having phone calls and emails with them, they started having them come into the office.
Oh.
But they stopped following it up with writings. Thank you for coming in today. It was great seeing you. Here's a recap of what we discussed. We went to their underlying case got dismissed because they failed to appear at their own trial. And their position is they had no idea about the trial date because you, lawyer, never told me we needed to be there for it.
And of course, the lawyer swore up and down they did,
Of
right?
course. And so I had a battle of experts at trial testifying to what I just talked about, the CYA letters, the plaintiff lawyer saying if it didn't happen, if there's no letter, it didn't happen because that's not the nature and course of the practice of law. We are all taught, as baby lawyers that you
Yeah.
send a confirming email after every phone call or confirming letter, et cetera. And that was one of the biggest issues in the case was whether the plaintiffs were told about something. And it also goes to one of the things we're here where we'll talk about a bit more was a competency issue.
Mhm.
The client's not documenting sufficiently the competency issue that was going on, and then going to the court seeking trial continuances talking about my clients are having competency issues. And so they were in the case alleging that client confidences were being revealed and all sorts, so all these things can be tangled together. And it kind of goes back to the documenting things being one of the most important things that you can do. So whether it's a conflict that we're talking about immediately here that's where it starts, because all of this stuff starts at the outset of your representation. Once you're in the thick of it, the wheels start falling off and you start, not following these best practices. If you establish it from the get-go, that's what will save you.
Yeah, 100% agree. All right, so we're going to get into some sort of practical tips. Now, this gets a little bit more into the sort of loss prevention world that I work in. Part of my job is answering our attorney to attorney hotline at Lawyers Mutual. So if you are a Lawyers Mutual insured, you ever have an ethics question, you can call our ethics hotline and you will get someone such as myself on there to talk to you about it. And so these are some of the tips I give out frequently when someone calls and they're like, hey, this couple came in and something's striking me a little bit weird. They want me to prepare this estate plan. Okay. And you want to talk it out. Here's sort of my tips for trying to manage what your inner gut is telling you, right? When you pick up the phone and make that phone call. So, number one, if it's possible, conduct separate interviews of the couple, right? That's going to help you make sure that there's not too much influence of one over the other. It's going to give you a better sense of whether there are any conflicts there that maybe aren't presenting right on the surface. Talk about their individual goals, right? And make sure that each client feels comfortable disclosing with you. Make sure they understand the confidentiality rules and how you will be sharing things with their spouse. We want clear engagement letters, what you are and are not doing, right? If you're an estate planning attorney, but no expectation that I'm ever going to do any kind of administration, right? Or different things. Make sure that you are excluding what you don't do in your retainer agreements. Document everybody's understanding. We already talked about that. And then put in any conflict of interest waiver that you have. I like to see very clear rules on what will happen if the potential conflict turns into an actual conflict, right? I want it to say specifically, if you guys end up in a conflict, I'm going to withdraw. I can't pick either of you. You're each going to have to get your own independent lawyer. Put that in the conflict waiver because there are occasionally breach of fiduciary duty cases where they come back and they say, I would have never hired you. I would have saved my money and I would have hired a lawyer. I would have hired my own independent lawyer from the outset. I have one question that came through the chat from Richard. I think it's Hofflin. Can you share forms or is there a library source where we can get them? In terms of conflict of interest forms, if you call your carrier, I know that I can speak for the carrier I work for, Lawyers Mutual. We do have forms on file. So if you think you have a conflict, call your carrier. They might have a form for you to use so you don't have to reinvent the wheel. Also, if you're not a client of Lawyers Mutual, but you want to call me and talk to me, I'm happy to sort of walk you through it as part of my sort of business development that I do for the company. So that's how I'd answer that question. All right, so we're going to talk about the red flags specific to the joint spouse representation in estate planning drafting. Big one, second marriages with prior children. Lots of conflicts come up there, especially after the couple is deceased. We see a lot of litigation after the fact where a stepchild or a child from a first marriage believes that they were supposed to fully inherit dad's separate property, right? There might be some commingling going on, and what was separate property is now a really huge, big question in the follow-up, probate litigation. So that's a big one. I see that all the time. I bet you do too, Adam, right?
I I am filing a reply to an anti-slap and demur this week in a case involving $1 billion, that's with a B, $1 billion estate,
Wow.
where it involved a marriage with prior children,
Yeah.
and this uh, natural daughter of dad and stepson are in heated. I don't even know how many different probate actions and lawsuits have been filed amongst them. And, it daughter turned to lawyers saying, this is all because this bloodbath of litigation is all because of your malpractice, that
Yep.
you did X, Y, and Z during the representation. Uh, and it wasn't a conflict of interest issue. It just is, this is just an area where you end up in the most likely to see yourself in a subsequent malpractice case, because that's where the fighting's going to happen. I mean, and I know you can talk to this too, is trust and estate is probably one of the highest, if not the highest area of legal malpractice.
I think
For
it's the
Yeah,
highest, at least in terms of what we write.
yeah, and so family being the second, and and a lot of times the family.
PI's in there somewhere with their blown statutes of limitation. Yeah.
Yeah, and so it's not that this red flag of second marriages with prior children is a big no. Don't ever represent anyone that
Right.
has that, because that's not realistic, and that's also, I think, a disservice. That would be a disservice of legal advice, that
Correct.
and because people need representation.
Yeah. But I
Um,
think it means tread slowly, right?
yeah,
Like step back, right? It's not just a single one-off estate plan that you're doing for a solo person that comes in your office. Take a minute
yeah,
and think about it. What are the potential issues here?
yeah. You got to look through them more closely. You got to it's even worth considering looking at other provision. Maybe you were only retained to revise X provision, but take a look and see, is Y provision in there that might affect things, because just because you were only hired to revise X doesn't mean the lawsuit isn't going to come saying, well, you didn't go and revise Y too.
Or at
You
least you didn't tell me about the risks with respect to
Yeah,
why so that
yeah.
I could make an informed decision.
I would have never revised X had I known about Y, is something I hear way too often. And so just because your job is only this big doesn't mean you shouldn't look at the other things, especially when it's the second marriage with prior children, or things like that, or the other one here, a disinheritance. Things
Yes.
like that are ripe for conflict down the line. And if the family starts fighting, where do they look when it's all said and done, after they realize they spent X hundreds of thousands or $1 million on legal fees that just depleted the family's estate? They go back and look to the lawyers.
Yep.
And unfortunately, the lawyers get looked at as that fallback plan for recouping their loss.
Yep.
And so, good practice, establishing good practices here, treading with caution, can help reduce the chances that you end up calling up Amanda saying, hey, I received a lawsuit, and Amanda calling me up saying, hey, we need defense for our insured here.
100%. And I think that, the situation you described, it's so unfortunate to me because I think when there's $1 billion estate plan, that lawyer more likely than not probably ends up with some form of a lawsuit because somebody's going to be upset and think they didn't get enough money. And that's just the unfortunate part of these large estate plans. And part of the problem is we're attorneys in California. every estate, if they're a homeowner, is close to $1 million minimum now, right? I mean, we're just doing estate, everything's getting more expensive. Everything, it feels like everything is $1 billion nowadays, right? So we have to think about that when we're going into these larger estate plans. Really take the time to make sure you've documented any conflicts. Other red flags, let's see, significant separate property. If one spouse has a big separate property interest, it's probably a good idea for them to have an independent lawyer. Not saying you can't do it subject to a conflict waiver, but it might be a better idea to make sure that they have another lawyer to look at their separate property. If there's a disagreement on beneficiaries, which we already talked about, your example was so great. I'm going to use that on Hotline. I hope you don't mind. I loved
Yeah,
that.
go for it. And
Yeah.
I see there's a question from Alana Martin. What are your thoughts on waivers for clients in the same family? For instance, you did parent estate plan, now their children want you to do their estate plan. That's a great one. That is
Mhm.
a really, really good question because I'm going to give the lawyer answer. It depends. Are the parent, you, my first thought is who are the beneficiaries of a parent's estate plan? Because if it's children, then you have, one of the things we'll talk about here is duties owed to non-clients. You then start getting into a little murky areas. Now the children are become clients as well.
Mhm.
You potentially have a really big issue because what happens when parents come to you and say, I don't want my children to receive my estate anymore. I want it to go to, the Natural History Museum.
Yep.
They want to donate it all. But children are your clients now.
Yep.
So, so though, so yes, conflict waiver could be good in those situations. But you also may want to just consider passing because that might create a situation where you potentially have to lose everyone.
Mhm.
That's really the risk with taking on a conflict, as Amanda's talked about, is that it's not just losing the new one, but it's potentially losing the old one too. So you know, your better bet of saying, sorry, kids, I can't, do this for you, but I have a, great recommendation here. Go talk to this
Yeah.
lawyer.
Yeah. Yeah.
Um, but again, if the children aren't the beneficiaries, you know, or the parents are deceased or anything like that, again, it's going to be fact specific, but that would still be a good situation to absolutely get a conflict waiver between parents and children
Mhm.
and consider going back to one of the things there about interviews, maybe go back to go back to the parents, interview them and see, is there anything happening in the family which could lead towards parents wanting to disinherit children for which you now have, uh, a conflict in your duties of loyalty.
Yeah, absolutely. Absolutely. We have a question from Marshall Glick, one of my favorite estate planning lawyers, who's been a member of the San Fernando Valley Bar for 1 million years, I think. He's such a great member. He says, in cases where there are children from a prior marriage and the estate is substantial, isn't it best to require as a matter of office policy that one spouse be represented by a different attorney selected by that spouse, at least require that the estate plan document drafted by one attorney be reviewed by an attorney representing the other spouse prior to signing? Absolutely. Absolutely. That is best practices, right? I'm not going to tell you that the rules require it, but is that best practices? 100%. Yep. Marshall nailed it there with the question.
And the other thing too is when we talk about in some of these cases when it's just reviewing a plan, it doesn't necessarily need to be that this other attorney is coming in and having this full force representation.
Yeah.
It can just be that they hire another attorney to conduct a review of the plan to make sure that person's not getting screwed over for, right? I mean,
100%.
and that's not a terribly expensive thing too. So I mean, that should be something that's encouraged. I mean, really, how much would it cost for a lawyer, for another estate planning lawyer to just quickly look over an estate plan? Obviously, if it's a very complicated and detailed one, we're talking about a very substantial estate, it might be, it could be a little bit more. But again, if the estate is substantial, presumably there's money there to be able to afford it and it's worth
Right.
it.
It's worth it not to have that later challenge. And we've got some family law lawyers on here today. I don't think it's any different than the family law lawyer who drafts a prenup and says she's got, the one of the spouses needs to go get independent review by their own independent lawyer to make sure that this prenup stands up in court. I think it's a very similar idea. Let's see, any other red flags? I think we sort of talked about it. If there's an intent to disinherit, you might have a potential conflict there that you need to worry about. So that's definitely a red flag to slow down. And then we're going to talk more about undue influence later in the presentation. So I'm going to skip over that. Um, where you were asked to represent the trustees and the beneficiaries. So let's talk about the situation where the testator has died. You're the attorney who has been hired to do the trust administration, right? And you're only the attorney for the trustee, but actions that you take are going to have an impact on the beneficiaries, right? So if there's something that is requiring you to represent both, I would say you shouldn't do that. Represent only the trustee or only the beneficiaries. That's pretty easy. Just send a letter. This is my office practice. I only represent the trustees. I can't take on beneficiary representation. And that's how you deal with it. But don't ever take on both at the same time. Obviously, beneficiaries can question the trustees' actions. There can be disputes over distribution. And you could have a real sticky situation on your hands. So represent one or the other, but not both. Okay. Real quick on this presentation, I just wanted to touch on the conflicts that can come up when you are representing a fiduciary, where there's a professional fiduciary appointed under a trust plan. Remember, your duty runs to the fiduciary in their representative capacity, not to the estate or beneficiaries individually. That's a slightly different thing. So I mention it here. Those who do professional fiduciary work are probably well versed in this, but I added it to the presentation just in case. See if I can move us on. Okay, so let's talk about client capacity. This is another one that Adam and I see all the time. Testator dies and beneficiaries come out of the woodwork and they say, my aunt had a bunch of undue influence, brought grandma in to do the modification to their estate plan, disinheriting me. And I know that grandma would have never done that. It's because she had dementia. Okay. Anybody who's an estate planning attorney, you've seen this fact pattern, right? And so what ends up happening is the beneficiary then sues the lawyer, arguing that you didn't handle the capacity determination appropriately. Therefore, I got stuck with this amendment in probate litigation. Maybe they did a capacity challenge there and it didn't work, but then they try to bring their legal malpractice claim anyways. I've seen that happen. So lots of different ways that this can sort of shake out. But the basic rule is that the lawyer, if you believe that they have diminished capacity, you want to try to keep a normal attorney-client relationship with that testator, but also assess whether the client can understand and make reasoned decisions about the estate plan. Document your capacity assessment and send it out for a certificate of independent review. Okay, that'll prevent those legal malpractice claims there. So how do we document capacity? First, mental status assessment. Ask questions that test their understanding, right? Family relationships, all the type of stuff that you normally get in that client intake interview, you're going to ask of the testator. If they're brought in with someone, right, a relative, a caretaker, make that caretaker step out while you're meeting with the client so that you can assess whether they have independent decision-making ability. Make sure they're not under pressure. If it's appropriate, request medical documentation. I don't really love this one. You guys aren't supposed to be doctors, right? But if for some reason there's a report recently that says, no, grandma doesn't have dementia, and somebody mentions it, maybe take a look at that. And then create a detailed file memorandum about your assessment.
On number 3 with the medical, it's more, again, it's another CYA sending the client out for a geriatric psychologist to evaluate and provide you a report that says whether the person is susceptible to undue influence, or whether the you're putting it in the doctor's hands of saying, which is the medical professional, the person who is trained specifically to do this, to make those assessments and to say whether the doctor believes the person has the capacity or not to make the revisions to their estate plan. There are some legal limitations to when we're dealing with non-clients and capacity determinations, but there are creative ways to get around it, and you having just a document in there saying, no, look, I sent them to a psychologist said this person has capacity, therefore I felt comfortable moving forward because I'm relying upon a trained professional's opinion here. And that's the gold standard there.
Sorry, dog was about to start barking and then I muted myself, then I couldn't figure out how to unmute. 100% agree. It's more of a CYA piece of practical advice. I included a slide for you guys on when you are allowed to breach confidentiality if you think someone is suffering from undue influence. I don't want to spend a ton of time on it, but it's essentially an exception to the duty of confidentiality and privilege. If you need to step in because you think someone's being harmed, I put the rule here for you. Let me go to the next slide. All right, so let's talk about some of the warning signs of undue influence. I've given you the official definition, right, where someone has their will being overcome. Courts look at the vulnerability of the victim, the influencer's apparent authority over the victim, the actions and tactics used, and the equity of the results. So that's the legal definition. But let's talk about the presumptions, which I'm sure most of you are aware of, right? We've got the probate code section 21380 creates presumption of undue influence in specific situations, requiring the transferee to prove the transfer was not the product of fraud or undue influence. It happens where the attorney is the drafter that benefits the lawyer or the lawyer's family members. Straight up, just please don't do this. Don't draft an estate plan that gives something to you unless you're doing it for a family member. And even then, maybe help them hire an outside lawyer. It never works out cleanly that the attorney take a gift under an estate plan if they're also the drafter. It's got conflicts all over it. Of course, there's exceptions if they're a blood relative, but even in that situation, I recommend not doing it because most people don't know this. If you've zoned out, maybe pay attention to this part. But if you were ever sued by a family member for legal malpractice, that is likely not covered under your policy. So here's my hot tip for the day. If you don't want to do freebies for your family members, then you tell them, I can't do freebies because my malpractice insurance doesn't cover it. Easy way to wipe your hands of the freebie request. Anything you want to chime in there? Let me see.
That one is one where,
just don't do it.
Just don't do it. There's not a conflict way. Just don't do it. Have them have a separate attorney.
Yep.
It's as simple as that. Have a separate attorney.
Yep. So what are some of our red flags for undue influence? Is there isolation and access to control over the testator, right? If someone comes in with a caretaker, they're the sole caretaker, there's not a lot of other people around, that's a big red flag. If people seem like they're in a rush to get an estate plan done, that should be a red flag. That's time to slow down and make sure you're not doing anything that could harm the testator or potentially their beneficiaries, because that's where the big liability comes in. If you prepare an estate plan where it's found that there was undue influence, those beneficiaries, when they can't get the money back from the person who did the undue influencing, right, from the real tortfeasor, they turn to sue the lawyer because they know the lawyer has insurance. So if it's inconsistent with a prior plan, like there's a big, huge shift in what they're trying to do, that's a red flag, right? Versus coming to you because, hey, she bought a new property and she needs to put it in the name of the trust or whatever. That's obviously minor and minuscule versus I want to disinherit my son and give everything to my daughter who's been taking care of me. That's a huge red flag. Also, if you have a vulnerable client, They've got a recent loss, a big loss in their life, a spouse died suddenly, cognitive decline, physical dependency, social isolation. Any of those things can result in undue influence. Make sure there's no disproportionate benefit in what they're trying to do. If there is a non-family caregiver with the testator, that results in a legal malpractice case 9 times out of 10. I see it where the caregiver moves in, towards the end of life. The testator makes a big change, giving nearly everything to the caregiver. The lawyer is going to get sued in that circumstance because the beneficiaries are going to be pretty upset. And then if that third party bringing the client in is providing information or answering for the client, that's also a really big red flag. I'm going to let Adam take over this next slide, and then I'll look at the chat for questions. I believe this was oh wait, no, this isn't the one. Is this the one you sent me?
No, this is the one you put in there. But
Oh, I put this one in there.
There is a question in the chat and I was answering some as we go, but there's a question about going back to fiduciary representation. I think to just answer this one quickly, attorney represents trustee in trust litigation. Trustee's spouse or significant other gets a depo subpoena by opposing counsel at some point. Spouse has no representation. Trustee and spouse want trustee's attorney to represent at depo. Assuming conflict waivers, would this be okay or should it be referred out? It's a little hard to say. It's representation at a deposition is probably of least concern. It's just not a very the consequences and risks involved are not terribly high from it. Like the fallout that occurs is not very high. And I would say it kind of depends on the spouse's involvement. Is the spouse the successor, a second successor? Is the spouse a beneficiary, but a beneficiary that's not suing and another beneficiary is? In that situation, I would say maybe don't touch it with the, representing both, maintain a slightly cleaner division there.
Yeah.
But, if it's not, if things don't seem terribly controversial, and the spouse has just precipient knowledge about things, this is like, trustee malfeasance or something like that, and the spouse might have precipient knowledge of things like that, then I would say it's likely fine because there's not really a conflict between the trustee and
Like
their
they're
spouse.
aligned. Yeah.
Yeah. So it just really kind of depends more on the nuances of that representation. But again, it's one of those things, if it just use your gut. If something doesn't feel right, refer it out. If you have doubts or questions about it, refer it out. You're better off doing that.
100%. I agree. That's a very fact specific issue. And again, if your carrier has an ethics hotline, just plug in my own self here. That's a good one to call on, right? Here's what I've been asked to do to represent this person at deposition. I'm not sure how I feel about it. Bounce it off someone who knows something about ethics and come up with your answer that way. That would be part of your due diligence there. And I think you probably get the right result most of the time. I'm going to skip this slide. It's just an example of a lawyer who gave himself a gift in an estate plan. It didn't end well for him, as you can imagine. Let's see. This is a slide where we talk sort of about just the process. This is just designed to give you a visual of how to document your practice, right? So you document your initial client interview, all the family relationships, asset overview, all of that, but also your assessment of the testator and whether you think they have capacity. Record those questions that you asked for that capacity determination. Maintain copies of all your client communications. That one's obvious. It's part of the client file. We all know we need to keep records. When you do the review and execution of the estate planning documents, make sure that you describe the documents during the review process. Anything nuanced, make sure you make a memo to your file just in case, because we don't always remember, right? And like Adam and I said, if it's not in writing, it didn't happen. And then post execution, document any final instructions, how you're going to store the documents. Just a pro tip to any estate planning lawyers, please do not keep original estate plans. I doubt any of you are doing it, but if you still are keeping originals for the client, Please get out of that habit. It'll also make your life so much easier when you go to retire and you want to destroy documents. Give the original estate plan back to the family. Okay. Let's see. We're getting close on time here. I kind of want to flip through. So I have a couple of slides on engagement agreements and how to make sure that you're limiting yourself, providing things like I'm not going to give you tax advice or I'm not going to review beneficiary designations on insurance forms. Things like that need to go in your retainer agreement to limit your liability. But most of this, I think that we've already talked about in
I'd,
terms
I'd
of.
also I'd also say updates based on trust. You prepare the trust. You have language in there that your representation ends once it's prepared, executed, and
Yes.
delivered. You're not responsible for monitoring changes in the law that might
Right.
affect the trust that you drafted for them.
That
That
is such a key one that I would like you to say it again. Do you mind, Adam?
Yes, of course. So please, please, please include language in your retainer agreement that one indicates the end of the scope of your representation. Your representation, if you're a drafting attorney, ends when the estate plan is executed and delivered to the client. That's going to help me when I make a motion under Code of Civil Procedure 340.6, which is the statute of limitations, because I can say there's no continuous representation. So that's important there. But
Mhm.
also language that you're not responsible for monitoring changes or updates to the law that may affect the trust or the estate plan that you prepared.
It's
Uh,
especially important here in California where we have random propositions that get passed, right, that are going to change structures. So that language that Adam's talking about is really key to prevent a claim later of, hey, I thought you were my estate planning lawyer. Why didn't I get a letter on proposition blah 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 and how it totally kills me on taxes? I should have redone the beneficiaries will go, oh, mom should have redone her estate plan, right?
and
So
if you do send out those letters, because law comes down, hey, I've been preparing estate plans this way, and this law is going to affect. I know it's going to affect my prior clients, all that. If you send out letters to your existing clients, prior clients, you should also include language that indicates you are not representing them again with the new estate plan until a new retainer agreement has been revised. Because you just send out the letter without that language, they're going to rely on it saying, oh, I thought you were going to make the change. You didn't make
that
the
you would
change.
just do it for me.
Yep. So again, it's making sure, again, it's great business development to try and go back and here's an opportunity to revise, all these estate plans, but you need to make sure you're doing it right so that you're not going to walk into a malpractice lawsuit later.
Yep, 100% agree. Very good advice. In terms of if you have a conflict and you have to withdraw, my only point here is document for your own file the reasons you're withdrawing, right? What red flags did you see? Anything along those lines. Give written notice to the clients, return documents and fees, and allow time for new counsel. Those are really my pointers. Doesn't apply too much unless there's active litigation. It's usually not a too big of an issue for you guys. Let me see. Yeah, okay. I just want to make sure we get through the next two slides and then we'll probably call the presentation because the remaining slides were kind of wrap up. So I know we're coming up on our time. I know we're at 1 o'clock. So if some of y'all need to jump on off, that's okay. But Adam and I are going to stay on. Okay, so here's sort of my common pitfalls in estate planning practice. These are the types of cases we see over and over. Missed tax planning opportunities, failure to advise on estate tax exemptions, portability elections, or gift tax consequences. We see these pretty frequently. So anytime you're dealing with any of those issues, just tread slowly. Beneficiary designation oversights where they think the attorney was going to modify the designation and then they don't. We'll see litigation later on from the beneficiaries who say, hey, I was supposed to get the life insurance policy. What happened? Or this didn't make it into the trust. Why didn't it? Right? Those sorts of things. Drafting errors, ambiguous provisions, failure to include what happens with the residuary, trustee powers, things like that. Those don't come up too often. That's sort of a throw in. And then obviously all the conflicts of interest that we've been talking about. These are more of the same checklists. I'm not going to go over and over about it. But the one thing I did want to talk about is make sure you're maintaining adequate malpractice insurance. Your malpractice insurance should match the value of the estate plans you're preparing.
Yep.
Do not be an estate planning lawyer with a $250,000 policy. There is no estate plan, really, unless you're doing lower pro bono work in California that is $250,000. Estate planning lawyers need a minimum of 1 million in coverage, and that may not even be quite enough. When you go to retire, purchase a lifetime tail. For any other lawyer, I might say, okay, a 1 year or a 3 year tail is okay. For estate planning lawyers, if you are retiring, you need a lifetime tail because those beneficiaries can come out of the woodwork because the harm on a legal malpractice claim, meaning the trigger for the statute, doesn't occur until the testator dies and they learn that the estate plan wasn't what they thought it was. Okay. So you don't want to be mid-retirement getting hit with some multi-million-dollar lawsuit and you have no insurance coverage because you purchased a 1 year or a 3 year tail. Any questions on that I can answer after we're concluded here.
I
All right. So here's
wholly
your
endorse
case,
that.
Adam.
Yeah, I wholly endorse upping your limits. It's as annoying as the higher premium is.
I get it. It's worth the peace of mind.
It is worth the peace of mind because that policy, their policies are burning limits, and that money goes very, very quickly in litigation. It disappears faster than you can imagine. So.
And just before we move on, so that just to explain a term that Adam's using, burning limits means that your policy of insurance has a certain amount of expense reimbursement on it that goes towards attorney's fees and costs. Usually on a legal malpractice policy, that is $50,000. Once that $50,000 is gone, say you have $1 million policy, to pay your defense lawyer's fees, your amount available from that million will start to diminish as you incur attorney's fees and costs. So your policy available for settlement or payment of a judgment might be down to 500 grand by the time you get to trial because you burned all those attorney's fees with discovery and law in motion and it was a particularly nasty case, right? So you need to think about it in terms of how much coverage you need, knowing that they're burning limits policies, and in the event of a claim, that amount gets whittled down from the fees and the costs.
Or worse, you get a $500,000 policy, which like Amanda says, not good. Or the 250 even worse. I mean, that's basically like driving around with 1530 auto coverage. It's just
when you own a home. Yeah.
Yes, it's just
the equivalent of that.
Makes no sense. And the worst case scenario is it's not just, oh, you don't have as much money to settle the case with, is we're going to trial and the carrier sends the email saying best of luck. And I'm sending you an email saying I need you to sign my retainer agreement and pay us a very large retainer because we have trial in a month or two or whatever it may be. And you're out of money on the policy. I mean, it was by far one of the most uncomfortable things that I have done in my career. It is the most nerve-wracking I have been in trial because I now know that the clients are fully bare. There is zero insurance if this went sideways, and things did go sideways. We got it all rectified in the end, but it's one of those ones where the clients still paid a lot of money out of pocket to be able to defend the case and ultimately prevail. And now it's up on appeal and they're still spending money. But had they gotten a larger policy, considering they were doing they're writing demand letters for $2 million, yet have a $500,000 policy. That should be a red flag. Like with estate planning, you're preparing estate plans that are $1 million, $2 million, they have $5 million in assets, and you have a $250,000 malpractice policy. That's not going to cover anything.
Not going to cover it.
And, as lawyers, there's a presumption, right or wrong, that, there's money in other assets. So the plaintiff's lawyer may not take your 250 and say, we'll cut the loss. They'll say, no, client, you own, lawyer, you own this home. You have these nice cars. You have all these things. You've been practicing for X number of years. You charge X $100 an hour. you
Mm.
can satisfy a judgment. And
Yep.
we don't care that you have to pay it over time. So yeah, up your limits. Um,
100%. All right, I'm going to let you take this slide on
yeah.
this case.
So important. This is the important thing. The most, I think, one of the most common areas of legal malpractice in the estate planning is that you're not going to get sued by your client. You're getting sued by a non-client. That I think is probably going to be more common than not. And it's one of the biggest uh, head scratchers of estate planning uh, in terms of the malpractice world, because, right, generally speaking, you can only get, as a lawyer, you only have duties owed to your client. You don't represent Joe Schmo across the street, so you don't owe a duty to him. But if Joe Schmo across the street was an intended beneficiary of your client's trust, you do owe a duty
Right.
to him.
Yep.
And so for you estate planning lawyers, the world, the whole universe of people that can sue you is exponentially higher than it is for me as a litigator who has a set of clients that I represent. So this is a case. This is one of the most recent cases on this, and the point of law has been reaffirmed in published decisions countless times. But basically, this was a little bit of a unique one because it's not just the specifics of preparing a trust, but here it had to deal with they prepared an estate plan, this trust, disinheriting, making it so that certain grandchildren wouldn't be able to inherit under the trust. But the client wanted the lawyer to also then prepare uh, stuff relating to these LLCs, and that is where the problem occurred because the lawyer didn't make it so those same grandchildren wouldn't be able to inherit under the LLCs. Ultimately, it turned into a malpractice lawsuit, and fortunately for the lawyer there, the court upheld the grant of summary judgment because it wasn't clear that there was a duty owed. Because again, you have to the non-clients, it has to be very specific. The court uses the term clear, certain, and undisputed. And the example they gave is do X. You must, do X that benefits the non-client beneficiary. In that situation, you didn't have it because the client never instructed the lawyer to also make it so that the grandchildren couldn't inherit through the LLCs. But it's one of those things that we talked about earlier where I said, okay, just because your scope of representation is this doesn't mean you shouldn't also look at all of this out here. It's one of those ones where ultimately the lawyers prevailed, and that's great, but there's a cost to getting sued. It takes your time away. I'm going to be meeting with you and saying, I need you to do X, Y, and Z for me. I need this information. That's time that you're not making money working on your own work. And then obviously too, then you have the fact of, hey, I got sued, and it's out there in the world of published decisions. So all that could have been avoided with a little bit broader, more careful work, even though the lawyer ultimately was vindicated and the court said you didn't owe a duty to the non-client. Just a cautionary tale of, again, looking a bit beyond what you're specifically asked to do. And then also again, it goes back to the documenting. If the client doesn't want, client did not instruct me to make it so grandchildren could inherit under the LLCs. That's a note in your file that makes it very clear and undisputed the opposite way that in terms of intent. So when there's a dispute over intent, we usually say there's no duty. But again, you're better off not getting sued in the first instance, right? The risk management is so much better.
So much better than spending all that money, even to get your victory. You're still a couple $100,000 in on your underwriting profile, and then your rates are going up, right?
And the time cost that goes into it
And
too.
you got to sit for your deposition. If you're sitting for your deposition, you're not billing a client, you're not preparing an estate plan, you're not making money. So if money's what motivates you, that's the reason to care about these things.
Or sitting 2 weeks in trial in downtown LA is
Yep.
also going to be a giant loss to your business as well.
Not pleasant. That cafeteria food isn't great. All right. So here's my review. I'm not going to go over it. I know we've gone over our time. I thank you guys for the very robust discussion. I'm going to stop sharing. I wonder if there was one more in the chat that I didn't see. Uh,
I think that's it in the
did we
chat.
get them all? Okay. All right. Well, I'm super happy. Adam and I will stay on if anyone wants to chit chat. Otherwise, thank you for being here today. And I hope you guys enjoyed the presentation. I hope to see all of you at Judges Night. Remember